This case starts messy and only gets worse from there. You've got a defendant already charged with operating while intoxicated causing death, and within days, he's right back testing positive for the same drug. That's not just a bad look. That's a legal disaster. The judge isn't just deciding guilt here, they're deciding risk. Can this person be trusted outside a jail cell? Or is this exactly the kind of situation where freedom becomes dangerous? Stay with this, because what unfolds isn't just about addiction. It's about accountability, credibility, and a courtroom losing patience in real time.
I had some at my house, which I disposed of.
In your nose or what? You what?
I used it, and
you used it. Then okay, so it didn't stay on the tray.
Honestly, I don't see how.
Really? Hold on. You know what? The thing I hate more than anything is when somebody lies to me. I don't know how he's going to do treatment, and the other thing is he doesn't test when he's supposed to test. So it seems to me I have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine, and kill somebody else.
Pause right there. This is the moment everything changes. He's charged with operating while intoxicated, causing death. And just days later, he's testing positive for the exact same substance? That's not a relapse from years ago. That's active use after being formally warned by the court. Judges don't just look at the crime, they look at behavior after. Legally speaking, bond is about trust. The court is basically saying, we trust you to follow conditions while your case is pending. Testing positive 4 days late, let me ask you something. If someone shows they can't stay clean for even a week after being charged with causing a death, should they be walking free at all? Or is jail the only way to protect them?
Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC, and then I need to address his. It's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was positive.
Hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
from August 28th.
I don't believe that's the date. Let me check.
In terms of his testing, I have on. So he's here on an operating while intoxicated causing death. So then he got tested on the 16th he was ordered. On August 20th, and he's positive for cocaine.
Correct, Your Honor.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows him.
He tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet.
I was informed about it this morning myself.
So Go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community correction would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth.
Okay.
To that testing, if he is allowed, Your Honor.
What was the intoxicant in the primary offense?
Okay.
He's charged. I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with. He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later, he tests positive for cocaine.
This is the turning point, and legally, it's massive. The judge isn't reacting emotionally. This is about pattern recognition. Courts deal with addiction all the time, and there are systems in place for treatment, rehabilitation, even second chances. But those systems only work if the defendant is honest and compliant. What we're seeing here is the exact opposite, a positive test right after arraignment, followed by inconsistent explanations. That immediately raises red flags. And here's the key legal insight. Bond isn't a right, it's conditional trust. The court is essentially saying, we gave you freedom with rules. You broke them almost immediately. So now the question becomes, is this someone who needs help, or someone who poses a risk if left unchecked?
And there it is, that quiet confirmation. He's positive again. This is what judges mean when they say someone is digging the... Notice something important. The judge isn't yelling just to yell. He's testing credibility. Courts can work with addiction. They can order rehab. They can order treatment. But what they cannot work with is dishonesty. The second the judge believes you're lying, your chances... And think about the bigger legal picture here. If he can't comply with simple bond testing, how is he going to comply with intensive probation treatment?
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And then you just smoked it.
I threw it away.
You threw it away? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I know. I disposed of the tray.
You what?
I used it, and
you used it. Then okay, so it didn't stay on the tray.
Right. And I disposed of the tray.
Yeah. Okay, well.
And since then, I haven't touched it since.
Okay, he probably stopped using because he's coming today. So somebody needs to answer for me. Why was he using after being arraigned?
I mean, I was
on this charge, and why was he using?
I have my theory, Your Honor.
Yeah, I don't think there's any answer.
Oh, darn.
Satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how.
Really? Hold on. You know what? The thing I hate more than anything is when somebody lies to me.
Okay.
Honestly, I'm not.
Okay. Well, just make sure because it has to be in your system in order for you to test positive. And make sure that it's been fine.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. You need all of this on the record.
And the last positive, 22nd to 7 days later?
Yeah. 7 days later. And the little bit he threw away.
Okay.
Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. Okay. But all I've done is I've used it in the chair that I sold. I've used it in the chair. That was it. When it's second, well, no, I have not. Okay. Well, we'll tell them that, but medically. I know. All I'm doing is telling you the truth. Okay.
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
And so that we know.
Thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
sure.
Clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly has a problem. He is willing to address that problem when he testing there. He is working, and he did voluntarily come here today and take a test. So he's asking you to
Not say that, right? No.
No, you have to say.
All right, anything else?
all I can say, Your Honor. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's going to do treatment. And the other thing is, he doesn't test when he's supposed to test. So it seems to me I have two options. I can let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine, and kill somebody else. Allegedly. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
All right, completely different energy, but equally dramatic. What you just witnessed is something courts see more often than people realize. A defendant trying to argue their entire case during... Here's the legal reality. Motions to dismiss require legal grounds, not speeches. Claims like no injured party or I'm not a criminal aren't magic phrases that override charges. And notice what the judge calmly pointed out. The delays weren't caused by the prosecution. That detail alone undercuts the speedy trial argument.
Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker, 15400, and AA Condolis, 02002, claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with Public Defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community, and I once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempted resistance.
If the court allows, he will spend $150 and test at a private clinic.
Could have done that
Yes,
before.
absolutely.
That's my point. I can't get them in because of time.
Well, we said by 4:30. Oh, sorry.
Find out if they can test him right now. If you come back dirty,
I won't.
I am putting you,
I have not taken none, I swear.
you know what? You need to be quiet about now.
He will test positive for the opioid blocker.
I understand that. Counselor, you probably should stop talking too.
May he take a sick day and test tomorrow morning first thing?
No.
Let's pause right here, because this is where the legal reality hits. When a court orders testing, it isn't a suggestion, it's a condition of freedom. Missing a test doesn't read as busy schedule, it reads as non-compliance. Judges often treat a missed test as seriously as a failed one because there's no way to verify what the result would have been. So the real question becomes, is this a genuine logistical hardship or a preventable mistake that should have been addressed before court day?
Your Honor, this is a PCC. We're requesting an adjournment of that, but as the court is reviewing, we have a bond violation.
Yes.
May I address the bond violation? Your
Yes,
Honor?
please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells them don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my
want, but go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids, because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine, yes, he has a prescription for that. He today can pull out of his pocket a copy of his pill bottle showing his prescription.
Oh, he told about grabbing it out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay. But you're saying he didn't know that he had to test?
No, that is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last 2 tests. The only reason he missed the last 2 tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond
violation. What was the other drug, the amphetamine?
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test. Yes. Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are 2 things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then, he has been clean. He missed the 2 tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's.
Your Honor, may I say something? I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
This moment is crucial. The defense is trying to separate a past positive result from current compliance. But without consistent testing, that argument collapses fast. Courts rely on patterns, not promises. If you miss tests after a prior positive, the court's concern shifts from "are you clean" to "are you trustworthy?" And trust, once shaken in a courtroom, is incredibly hard to rebuild. What would you do in his position? Risk your job to test or risk your freedom by missing one?
No, Judge, I had no idea there was a problem, but I will say this. When I found out this morning there was a problem, I called testing facilities and I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean,
I don't mind paying the money. And it's the facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how that
I want to fix this. I do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. Then when you know you haven't tested.
Sorry, Judge, I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in a system is Suboxone, but that's not everything that's showing up in a system from the initial test. I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
yes,
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming.
I just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this offense date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall, which will show up in his system as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had that amphetamine in his system. Granted, it was right after he was released from custody, but without the ongoing testing, there's really no way to ensure the safety of himself or the public traveling back and forth so much on our roadways. If he's not clean, I have the same concerns that the court does, but can't add anything additional.
Anything else?
Judge, I wish there was an easy answer.
Your Honor. Yeah.
If the court allows, he will spend $150 and test at a private clinic.
Could have done that before.
Yes, absolutely.
That's my point.
You're
My
exactly
point
correct.
is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing. Simple as that.
You don't.
It just shows one I took. I really did. My probation officer, well, she'll tell you. All right, here's
So
sorry.
before testing today,
I can't get him in because of time.
Well, we said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you,
I have not taken none, I swear.
you know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counselor, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. No answer yet. You need to go over there, see if you can test. If you don't
shall.
get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No.
Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still gotta come back here.
Sir.
And if you don't test, you're going.
Thank you, Judge.
Bye. Really? No, I'm kidding. You're welcome. He calls the case, the people versus Randall Jolly.
Reagan. Sure, maybe for the people within your honor.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument, you're going. Simple. And then the other portion of that is that I will allow defendant may test. What county is that? If you live in?
Allegan. Alleegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by the Community Corrections.
Apologize, Your Honor, may I have the PCC date one more time?
Is the 18th.
Your Honor,
His test results, he must sign a release so that his test results are sent to Community Corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, is that good enough?
That if as long as Community Corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to Community Corrections so that they can be reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at Community Corrections?
I do not. So what I suggest is you call over there, indicate his name.
Yep, very good. Thank you, Your Honor.
What we just watched is a powerful example of how courts balance fairness with public safety. In the first case, the judge made it clear repeated drug use after a fatal charge, combined with dishonesty and missed testing, destroys credibility. That's why bond was revoked, because the risk outweighed the trust. In the second case, we saw a different approach. Despite missed tests and complications, the judge allowed another chance, but with strict conditions and zero tolerance moving forward. That contrast matters. It shows that courts aren't just punishing behavior. They're evaluating patterns, responsibility, and willingness to comply. The big takeaway? In the legal system, your actions after being charged can matter just as much as the charge itself. If you found this case